Welcome to this Study Legal English sleep story, where you'll relax and gently drift into a peaceful sleep while passively learning about the fascinating world of mergers and acquisitions, or M&A for short. Remember that Study Legal English sleep stories are not legal advice and are instead here to help you learn legal English passively while you fall asleep. If you like this video, please hit the like button and subscribe to this channel. It helps me grow my channel and helps me know what content to produce. So now, close your eyes, settle in, and let your mind unwind. Get comfy, take a deep breath, and let this gentle pace of this narrative ease you into sleep as we explore the world of M&A. What is M&A? At its core, mergers and acquisitions refers to the process of one company buying or merging with another. The purpose of M&A deals can vary. Sometimes companies seek to grow their business, expand into new markets, or gain access to new products and services. Other times, businesses facing financial difficulty might look for a merger as a way to combine resources and avoid insolvency. There are two main types of transactions in M&A: mergers and acquisitions. In a merger, two companies come together to form a new entity. This can happen when companies of equal size and strength combine their resources to become more competitive in the market. By merging, these companies can reduce costs, eliminate competition, and take advantage of each other's strengths. In an acquisition, one company purchases another, either by buying its shares or its assets. The acquired company may continue to operate independently under the new ownership, or it may be fully absorbed and become part of the acquiring company. In some cases, acquisitions are friendly, with both companies agreeing to the terms. Other times, they can be hostile, where the acquiring company makes an offer to buy out the target company's shareholders, even if the board of directors opposes the deal. M&A can be incredibly complex, involving corporate finance, contract law, and regulatory issues. Lawyers play a critical role in ensuring that these deals go smoothly and that both parties are protected throughout the transaction. The role of an M&A lawyer. M&A lawyers are at the heart of these transactions. They guide their clients, whether they are buyers or sellers, through every stage of the process, from the initial negotiations to the final transfer of ownership. These lawyers handle a variety of tasks that require a combination of legal expertise, strategic thinking, and negotiation skills. One of the key roles of an M&A lawyer is to draft, and negotiate contracts. Every deal starts with a detailed contract that outlines the terms of the transaction. This can include the purchase price, any assets or liabilities being transferred, and the conditions under which the deal will be completed. Lawyers must ensure that their clients' interests are fully protected in these agreements, and they negotiate the best possible terms. Another important task is conducting due diligence. This is the process of thoroughly investigating the target company to ensure that there are no hidden liabilities or risks. M&A lawyers, alongside financial advisors, will review the company's financial statements, contracts, employee agreements, and any ongoing legal disputes. The goal is to verify the value of the business and identify any potential issues before the deal is finalized. M&A lawyers also handle the regulatory aspects of these deals. In the UK, for example, mergers and acquisitions involving large companies must be reviewed by the Competition and Markets Authority, the CMA, to ensure that the deal won't create a monopoly or otherwise harm competition. Lawyers ensure that all necessary approvals are obtained, and they guide their clients through any antitrust concerns. Key skills for an M&A lawyer. Working in M&A law requires a specific set of skills, and lawyers in this field often thrive in fast-paced, high-pressure environments. Here are some of the most important skills for a successful M&A lawyer. Firstly, analytical thinking. M&A deals are complex, with numerous legal, financial, and strategic elements to consider. M&A lawyers must be able to analyze large amounts of information, identify key legal issues, and develop solutions that meet their clients' goals. This requires a keen eye for detail and the ability to think critically about the broader business context. Secondly, negotiation skills. At the heart of every M&A transaction is negotiation. Whether they're negotiating the purchase price, the terms of a merger, or the conditions of an asset sale, M&A lawyers must be skilled negotiators. They need to strike a balance between advocating for their clients and reaching a compromise that allows the deal to move forward. Thirdly, commercial awareness. M&A lawyers need to have a strong understanding of their clients' businesses and the industries in which they operate. This is known as commercial awareness. Lawyers must understand not only the legal aspects of a transaction, but also the commercial implications. For instance, understanding how a merger will affect market share, or how an acquisition might impact the company's long-term financial strategy, is critical for providing effective legal advice. Fourthly, project management. M&A transactions involve multiple moving parts. Lawyers must coordinate with accountants, financial advisors, and regulators, all while keeping track of deadlines and ensuring that the deal progresses smoothly. Effective project management skills are essential for staying organized and ensuring that every aspect of the transaction is completed on time. Finally, communication. Clear and concise communication is vital in M&A law. Lawyers need to explain complex legal issues to clients who may not have a background in law, and they must ensure that all parties involved in the transaction understand the key terms and conditions. Whether it's drafting a contract or presenting a legal argument, strong communication skills are key. The phases of an M&A transaction. Let's explore the typical phases of an M&A transaction. From start to finish, each step plays an important role in shaping the outcome of the deal. Step 1. Preliminary discussions. At the beginning of any M&A transaction, there are preliminary discussions between the buyer and the seller. These discussions often involve non-disclosure agreements, NDAs, to ensure that any sensitive business information shared during the process remains confidential. This phase is all about exploring whether the two companies are a good fit and whether a deal is worth pursuing. Step 2. Due diligence. Once both parties have agreed to move forward, the buyer will conduct due diligence on the target company. This is where lawyers review the company's financial records, contracts, and legal obligations to ensure there are no hidden risks. If any red flags are found, they may renegotiate the terms of the deal or decide to walk away completely. Stage 3. Negotiation and drafting. After due diligence is complete, the buyer and the seller enter into formal negotiations. Lawyers take the lead here, ensuring that the terms of the deal are fair and in line with the client's objectives. They draft the necessary agreements, including the purchase agreement, and make sure that every detail is covered. Stage 4. Regulatory approvals. In larger transactions, especially those involving public companies, regulatory approvals may be required. M&A lawyers must ensure that the deal complies with UK regulations, including competition law. This may involve submitting the deal for review by the CMA or other regulatory bodies. Stage 5. Completion. Once all the agreements are signed and the regulatory approvals are in place, the transaction moves to completion. This is when the buyer pays the purchase price and the assets or shares of the target company are transferred. Lawyers oversee this process, ensuring that everything is properly documented and registered. Stage 6. Post-completion. Even after the deal is completed, there are often post-completion tasks to handle. This can include filing the necessary paperwork with Companies House, transferring intellectual property rights, or resolving any remaining legal issues. Lawyers also help with the integration of the two companies, ensuring that the transition goes smoothly. Trends in M&A. M&A is a constantly evolving field, shaped by changes in the economy, regulatory environment, and business landscape. In recent years, the technology sector has been a major driver of M&A activity, with companies acquiring smaller tech firms to gain access to new innovations, particularly in artificial intelligence, AI, and software development. Another important trend is the rise of environmental, social, and governance (ESG) considerations in M&A deals, as companies face increasing pressure to reduce their carbon footprint and adopt more sustainable practices. ESG factors are becoming a key part of the due diligence process. Brexit has also had a significant impact on M&A in the UK, with companies adjusting to new trade agreements and regulations outside of the European Union. M&A lawyers must stay up to date on these changes to provide accurate advice to clients. Conclusion. And now, as we come to the end of this overview of mergers and acquisitions, I hope you're feeling more relaxed and ready for a peaceful night's sleep. We've explored the key phases of an M&A transaction, the vital role that lawyers play, and the skills needed to navigate this complex area of law. Remember that this episode is not legal advice. It is just here to help you learn legal English while you fall asleep. So now let the knowledge gently settle in as you drift off to sleep. Remember, each M&A deal is like a carefully crafted puzzle. Every piece must fit perfectly for the transaction to be successful. And with that thought, let go of the day, rest well, and I'll see you again soon for another Study Legal English Sleep Story. Good night.